Yes.
Item number 1. This morning.
May it please, Lord.
Yes.
It is a PIL concerning wetlands and Ramsar sites.
Yes.
Your Lordship would recall.
It was Supreme Court order.
Yes, my Lord. If your Lordship will see the Supreme Court order, my Lord. Supreme Court order is concerning Ramsar site, my Lord. Kindly see page 12 of the Supreme Court order of 11th December 2024, my Lord.
Yes.
Page 12, my Lord, last paragraph, my Lord. Now the latest figure shows that these Ramsar sites have increased from 26 to 85, including 59 additional sites, falling under 5 other additional high courts, Patna, Bombay, Karnataka, Guwahati, as well as Uttarakhand. List of updated Ramsar sites has been given to this court, which is reproduced as under, my Lord. And Lordship will see all 85 Ramsar sites. So, Meghalaya, there is no Ramsar site, my Lord.
Yes.
And kindly come to page 16, my Lord. The Registrar General of this court is directed to send the complete list to all high courts, including the 5 high courts which are mentioned below. All high courts are these high courts where the Ramsar sites are there. And high courts are requested to treat the affidavit as suo motu public interest litigation, where an amicus be appointed if necessary to assist the court and ensure that Ramsar sites within their jurisdiction are properly maintained. We say this only as a continuation of our order dated 3rd April 2017, my Lord. So this PIL is qua Ramsar sites, my Lord, and there is no Ramsar site. So far as wetlands are concerned, my Lord, for wetlands, the Supreme Court is already monitoring, my Lord. That part also is there, my Lord. If your Lordship will kindly come to page 5, where wetland issue is wetland. There are 2 writ petitions. First writ petition was dealt in 304, my Lord, 304 of 2018 before the Honorable Supreme Court. And wetland aspect is being examined and monitored by the Honorable Supreme Court, my Lord. So far as Ramsar sites are concerned, my Lord, direction has been issued to the all Honorable High Courts wherever Ramsar sites are there to monitor them, my Lord. So we have carried out the exercise also, my Lord, in respect of wetland, and if your Lordship will kindly see the page 5 of the order of the Honorable Supreme Court.
Which you just not placed, that order.
Yes, same order, my Lord, same order. There are 2 orders passed. There are 2 orders, if your Lordship will see, same order of the Honorable Supreme Court.
Page 5.
Page 5. And this order, my Lord, is in writ number 304 of 2018. Prior to 2017, the figure given by ISRO regarding the number of wetlands in India having an area of more than 2.25 hectares was 2,01,503. The latest ISRO data, which is of the year 2021, shows that this figure has now increased to 2,31,195. Now these figures have to be checked on ground. The Wetland Conservation Management Rules 2017 and guideline issued thereunder prescribe that the next step after identification of such wetland is what is called ground truthing, which is the term given to the actual inspection of these wetlands by a team constituted by the state for that purpose. Step has, however, been neglected by almost all the states except the state of Punjab to some extent. As regard demarcation of these wetlands, all states have done nothing up till now. We have been informed at bar that each state presently has a wetland authority. In fact, regarding reading of Rule 5 suggests that the State Wetland Authority has already been constituted. Rule 5, by which the State Wetland Authority as well as such authorities in the Union Territories have been constituted, and power of these authorities have been given reads as under. And then your Lordship, Rule 5 is quoted, and after quoting Rule 5, my Lord, kindly come to page 10, my Lord. It is clear now that ground truthing and demarcation of wetland boundary is the next step, which is to be undertaken by each of the state, union territory, wetland authorities in coordination with concerned nodal department as provided under the rules. It is a statutory function which has been assigned to them under the rules. We therefore direct each of the state and union territory wetland authorities to complete ground truthing as well as demarcation of wetland boundaries of each of the wetland which have been identified for their states for space application sensor atlas. For easy accessibility of this, each of the state and union territory wetland authorities shall complete the work as expeditiously as possible, but definitely within a period of 3 months from today. Ms. Asoya Bhatti, London Additional Solicitor General, has assured this court that they shall be doing the monitoring which each of the state and shall file a detailed affidavit before the next date of hearing. So wetland aspects are, my lord, before the Honorable Supreme Court, and then
The difference between wetland and Ramsar.
Ramsar, if your lordship will kindly see my affidavit, the status report, where Ramsar is constituted under the Ramsar Convention of 1972. It is a convention which was signed by all the states, and it requires 9 criteria. Certain wetland 9 criteria. If one of the criteria is met, one of the criteria is fulfilled by the wetland, then it is declared Ramsar site, my lord.
It's the largeness of the body.
The largest and uniqueness is there, like it is supporting more than 20,000 species. It is supporting a kind of ecosystem. You also will find that that we have placed that Ramsar site. You also will see my status report and page 7, my lord. Page 7 of my status report. Identifying managing wetlands of international importance, and Ramsar Convention of Wetlands at page 8, my lord. The Ramsar Convention of Wetlands is an intergovernmental treaty that provides that framework for national action and international cooperation for conservation and wise use of wetlands and their resources. India ratified the convention on 1st February 1982, my lord. And you also will see in the middle Ramsar list. A key commitment under the Ramsar Convention is to identify and place suitable wetlands onto the list of wetlands of international importance, also known as the Ramsar list. Ramsar sites form a part of international network of wetlands which are important for conservation of global biological diversity and for sustaining human life through the maintenance of their ecosystem and components and processes and services, my lord.
We have read your affidavit, your report.
Yes, my lord.
There are wetlands, but they do not cannot be categorized as a Ramsar site.
Yes, that is, they cannot be. And if I do it also, my lord, then we have to go it to the ministry. Ministry will take it to the international convention, and international convention then will examine. So as of now, none of the criteria of Ramsar site at page 9 are fulfilled by our wetland, my lord. So far as wetland identification is concerned, my status report says we have identified and we have placed certain reports also before the Honorable Supreme Court, my lord. If your wetland aspect is being monitored.
What is the High Court to do? Public interest litigation started. This is the situation. No.
This is
thereafter.
Because Ramsar, this public interest litigation was started in respect of Ramsar sites, my lord, because wherever there are Ramsar sites, High Court is required to monitor them. In Meghalaya, there is no.
But whatever is the result of our inquiry.
Yes, my lord.
Now, how is it placed before the Supreme Court? This matter is this matter pending, or
wetland matters are pending. Ramsar sites matter have been relegated to the High Courts wherever there are Ramsar sites.
that is disposed of.
That is disposed of.
That order you placed.
Yes, my lord.
All right. The learned Advocate General. No, before that you write. This public interest litigation was started pursuant to an order dated 11 December 2024 by the Supreme Court. Full stop. It requested us to initiate this litigation for the purpose
Page 17, third line, my lord. Last page.
ground truthing, GROUND, of wetlands and identification of Ramsar, ARAMSAR sites amongst those water bodies as explained by the learned Advocate General, identification of those water bodies in this state. As explained by the learned Advocate General, not all water bodies can be categorized as Ramsar, full stop. Water bodies of a particular minimum area, depth, unique nature and characteristics. Including its natural habitat. Qualify as Ramsar sites. The purpose of the Supreme Court order was to ensure that suitable orders are passed by the High Court upon the state for preservation and maintenance of these water bodies in accordance with in accordance with the decisions taken in an international convention. Paragraph: the Learned Advocate General has filed a report dated 29th April 2025. In compliance with our order dated 8th March 2025, Learned Advocate General has with the greatest detail now you pointed out the submissions of the Learned Advocate General have been most informative and informative, convincing and detailed. Full stop. He placed paragraph 10 of the affidavit which stated that all categories of wetland comprising of 66 lakes stroke ponds, 1 OX bow stroke cut-off meander MEANDER, 6 riverine wetlands, 18 waterlogged bodies, 100 rivers and streams, 9 reservoirs, barrages, and 25 tanks stroke ponds had been inspected by the Meghalaya State Wetland Authority with the collaboration of the Chief Conservator of Forests Administration, Department of Forests and Environment of the said government, full stop. Within quotation, ground truthing of these wetlands had been accomplished. It was opined by the Chief Conservator of Forests of the said government that no wetland, that none of the above wetlands qualify as Ramsar site. The paragraph. The said report is accepted and taken on record. We noticed that the matter is pending, Mr. Advocate.
So far wetlands are concerned, matter is pending, my lord. Ramsar,
we find that the Supreme Court writ petition in which the said order, the Supreme Court writ petition bracket 304/2018, in which the said order was passed by the Supreme Court on 11th December 2024 is still pending. Although there is no direction, paragraph, although there is no direction to this effect, we direct the Registrar General of this court to prepare an affidavit in the said writ petition before the Supreme Court on behalf of the state of Meghalaya, and this court, stating the above steps which have been taken in compliance with the said order, enclosing all orders passed by this court, and the said report dated 29th April 2025 of the state, full stop. The said affidavit should only be filed after obtaining appropriate leave from the highest court. This public interest litigation is disposed of.
Number 2.
Yes.
Yeah, please, Your Lordship. Your Lordship, I file in this case under Order 41, Rule 27, seeking permission before this Honorable Court to file 3 documents, Your Lordship. Appointment letter, joining letter, and letter dated 21/3, constituting the selection committee, Your Lordship. Your Lordship, in the writ petition, Your Lordship, despite notice was served to me, due to lack of knowledge, Your Lordship, I could not appear, Your Lordship. As such, the matter proceeded ex parte, Your Lordship. Hence, I am seeking permission to file these documents, Your Lordship, along with the reply in the writ appeal.
What is the writ about?
Your Lordship, here the one post was advertised, Your Lordship, for the post of councillor, Your Lordship, wherein the appellant herein also participated along with me, Your Lordship. Your Lordship, the appellant here successfully cleared the written along with me, and a written personal interview was called, wherein I secured the highest mark, Your Lordship. Thereafter, Your Lordship, I was given appointment The same appointment was challenged by the appellant, which was dismissed by the learned single judge, Your Lordship.
You did not file any affidavit.
Your Lordship, no, Your Lordship. I was served with the notice in the writ petition, but due to lack of legal knowledge, I did not appear. As such, the matter proceeded ex parte. The writ petition was dismissed, Your Lordship.
What are your grounds in the writ petition?
Your Lordship,
What are your grounds in the writ petition?
Your Lordship, the grounds, the appellant could say.
But you are the state.
No, Your Lordship, I am the private party, Your Lordship. I am the respondent number 2 who got the appointment, Your Lordship.
No, on what ground your appointment was challenged?
On the ground, Your Lordship. On the ground that they did not disclose who constituted the selection committee, Your Lordship.
What are your grounds?
My lord, my grounds are that, my lord, when I was appointed as when the post of the councillor was advertised, my lord, firstly, my lord, there has not been mentioned that the post was consist of 2 tiers, that is of the written and the interview, my lord. Secondly, my lord, the learned single judge, while passing the impugned judgment, my lord, has failed to consider that in a public employment, my lord, the department selection committee can recommend the names of successful candidates to the appointing authority, my lord, for appointing. But in the present case, my lord, the respondent number 1 has not disclosed in the affidavit in the opposition, my lord, which the authority has approved constitution of department selection committee, and the department selection committee to which the appointing authority has recommended the name of the respondent number 2, my lord, for appointment. The appellant has the apprehension that the chairperson of the departmental selection committee is also the appointing authority, which is wrong, my lord.
The state has filed an affidavit.
My lord,
Lordship, we have filed. I'm appearing for the state, my lord.
We have filed.
Lordship. And our stand is that, my lord, since the appellant here, my lord, they had consciously participated in the selection process and they did not challenge the advertisement, my lord. And for the reason that the results was not predictable to them, they had filed the writ, my lord. And the single judge had rightly pointed out that the writ petition is devoid of merits, my lord. And I have some authorities, my lord, which I would like to place, if my lord, with your permission, to substantiate my arguments, my lord.
Yeah. Where is the order?
the order is at page 64, my lord, Annex J. The relevant paragraph is para number 4, my lord.
You see, at some stage the court will give him a chance. Even if we don't, Supreme Court will give him a chance to file an affidavit. So it's better you go back to the trial court and get it heard afresh. Otherwise, the appeal court has to go by a circuitous procedure. Order 1, Rule 27, give him leave to file documents, then hear out the appeal. It is better he files an appeal before the trial court and the trial court hears you out again.
My lord, I have no objection if my learned friend will file to bring the necessary documents, my lord.
What's court order very expertly. They filed an appeal and they want to file an appeal. It's better it is a dismissal order. So you go back to the trial. The private respondent has made an application in this appeal. Paragraph. Although the order under appeal in his favor by dismissal at the threshold of the writ petitioners, writ, comma, comma, the applicant did not file. Please read up the whole sentence. No, that is already.
Although the order under appeal is in our favor by dismissal at the threshold of the petitioner writ, the applicant did not file.
Although, what was it? Although
Although the order under appeal is in our favor by dismissal at the threshold of the petitioner's writ, the applicant did not file.
no, as a matter of abundant caution, the applicant wants to file an affidavit in opposition to the writ. Full stop. This he seeks to introduce in the appeal through an application under Order 41, Rule 27 of the Civil Procedure Code. Paragraph. Unless the circumstances are exceptional, a party to an appeal is not allowed to run a new case or introduce new documents The specific grounds are mentioned in order 41 Rule 27 of the Civil Procedure Code. Such limited grounds are if the document, in spite of exercise of due care, could not be located and produced by a party to the court. Secondly, if the document was suppressed from the court by the adversary. Also, if it was taken away or suppressed by the adversary, or if the court did not allow production of the document, it is difficult to run the applicant's case on one of the grounds above. Parallel. However, we think that the ends of justice would be subserved if these documents disclosed by the applicant are also considered by the court. In those circumstances, we remit this matter back to the trial court after setting aside the improved order with a direction permitting the appellant to file his affidavit in opposition by 7th May. Affidavit and reply may be filed by 16th May. This. This appeal is accordingly disposed of. List the writ on so and so before the learned single judge, subject to his lordship's convenience. This appeal is disposed of.
Give me
I'm deeply obliged, Lordship.
Number 3.
Yes.
May it please, Lordship. Lordship, we are jointly praying that the matter may come up after a week as the conducting counsel for this response number 5 is in disposal of yours. I have no objection.
The state has not made this prayer, Your Lordship. It's just between the
Appellant and the-
appellant and the respondent number 5, Your Lordship.
When do you want it?
When do you want?
Lordship, after a week. After a week, Lordship. A week time may be allowed.
The learned counsel for the state was prepared to argue the appeal. However, adjournment is prayed for. No, however, on the prayer of adjournment on behalf of the appellant and the respondent number
5.
Respondent number 5, this appeal is adjourned till when? Tell me, madam.
On the 7th, Your Lordship.
7th May. Yes, call the last matter.
Oblige, Your Lordship.
Number 4. Please, Your Lordship. Your Lordship, I've taken instruction from the respondent. Your Lordship, she will take the respective appointment. However, Your Lordship, I have a very small prayer. Your Lordship, if you would kindly consider monetary benefits towards the respondent, Your Lordship.
Good. This selection to the post of
LDC. Lower Division Clerk.
Clerk, Your Lordship.
direct.
Direct recruitment.
The selection procedure for direct recruitment of lower division clerk was challenged in this writ on various grounds of irregularity. The writ petitioner was the second waitlisted candidate in the panel. Alright, second listed candidate in the list. When the appeal was being heard, it was submitted by Mr. Muzika Learned, Deputy Solicitor General, that a fresh selection process that a fresh selection process had been concluded, filling up all vacancies. And that all the posts had been filled up. Later, during the course of hearing, Learned Counsel submitted that in that selection, one selected candidate had not joined or declined the appointment
Resigned from after joining.
and resigned. And therefore, paragraph. In those circumstances, he also submitted that his client had no objection if this vacancy was filled up by appointment of the appellant writ petitioner. We thought that it would be just and meeting the standards of fairness if the waitlisted candidate number 1 was noticed. Stop. Accordingly, he was noticed, full stop. He appeared in court on 24th April 2025 and expressed his unwillingness to accept the post if offered. In those circumstances, we think it would be just and equitable if the writ petitioner, being the waitlisted candidate number 2, upon opting out of waitlisted candidate 1, be appointed to the subject post. This is so because in our opinion, a new selection process or recruitment process is not necessary. As the earlier panel is not even 1 year old. Next, we ordered accordingly, directing the appellant, Northeastern Indira Gandhi Regional Institute of Health and Medical Science, to appoint the respondent. Sorry? To appoint the respondent in the such appointment should be made with prospective effect and within 4 weeks of communication of this order.
My lord, this is a small prayer. The learned single judge imposed a cost of 50,000 rupees, my lord.
1500,
50,000, my lord.
50.
My lord.
Well,
That may kindly waived, my lord. Since this we are giving appointment, my lord.
the direction for payment of costs of rupees 50,000
My lord.
by the Meghalaya, no,
By the learned single judge to
by the appellant to the respondent is set aside. Appeal disposal. MC disposal.
Hello, Raj.
highly